Donc je passe la parole tout de suite à Frédéric.
So I would like to give the floor to Frédéric Bourhon, who is going to be the fourth speaker of this morning. Is going to talk about trust, human rights, and rule of law. Thank you very much, Jean-Benoît. So I will be actually the last to make a presentation this morning, and in 20 or 30 minutes it might be difficult to talk about trust, human rights and the rule of law, so it might be quite a challenge. So I decided to take a few shortcuts. I'm sorry for that, but we hope to be a bit more detailed during the debate or the Q&A session, which will take place later on. Well, we have heard about many definitions of trust. Trust is not easy to define, and I would like, if you don't mind, to suggest a definition which might be fully in line with the literature, and mainly the German literature. More or less 15 years ago, and here is the French translation of that definition. The trust in the state and its institution is the individual's inherent expectation that the state will behave as a democratic state governed by the rule of law, that it will fulfill the tasks assigned to it by the Constitution, and that it will respect and protect the fundamental rights of the individual. So it means that we need to fully comply with the Constitution of each member state, mainly in the field of fundamental rights. So thanks to that definition, we have this notion of expectation, Erwartung, in German. So we have some expectation at the level of citizens. And if we meet those expectations, it is obvious that this will lead to a certain form of trust. So what do we mean by expectation? And I would like to refer to the Human Rights Declaration, and I've decided to make this element appear on the screen. So in bold letters you can see a connection between human rights and implicitly this notion of trust and the issue of corruption. When there is where there are no human rights, government might be corrupted, which means that we need fundamental rights with a view to secure trust. And the second preamble, element of the preamble here, is related to the fact that the fundamental rights might give some idea of purpose to the state and to the political institutions, so that it will be possible to have a kind of benchmark of the different actions with a view to compare at any moment whether things are fully in line with the political institutions and whether the different elements are respected. So expectations might become much more tangible thanks to fundamental rights. And against fundamental rights as well. What do I mean by against fundamental rights, i.e. based on the elements, based on the limitations? What are we ready to accept as limitations in terms of human rights? And that's part of the expectations we might have regarding the state. And I will come back on this element to determine this against the limitations of human rights. And in terms of expectations, you have no guarantee at all, of course. There is always a possibility or a risk attached, to this notion of trust, and we know that this might have an impact on the future. So I will try to see to what extent fundamental rights can be a vehicle of trust or vehicle for trust, or of distrust as well. I told you that maybe I would have a kind of binary approach. It might be a little bit based on this type of binary approach. Well, I would like to refer to the history. If we refer to the history, can we trace this notion of trust? And I would like to refer to Antigone's. It's a play, of course, which did not create as such fundamental rights, but it's very interesting because the character goes against a decision made by King Creon. And, well, you probably remember all the issue about the funerals, and she decided to refer to the gods with a view to go against the point of view of Creon's. And Antigone's role is the one of someone willing to be spontaneously opposed to the arbitrary decision made by Creon, and to fight this despotism, the despotism of Creon. The Magna Carta is another example, and we have British colleagues here who might have a lot to say on the topic. I will have a very, very brief analysis, but we have a kind of contradiction here, because the signing of the Magna Carta was a landing moment in the field of mutual trust, and on the other hand, you can, and I'm saying it in English, I quote it in English, it is a way to come to an agreement. Essentially, a set of rules laid out for the first time how the king should govern the country, and so on and so forth. Well, is it possible to reconcile both ideas, which might appear to be quite the opposite? That is this notion of conflict, the lack of trust, and this charter, the Magna Carta, is likely to create a new type of trust, not necessarily from the whole people, but at least from the key stakeholders. Let's move forward on the timeline, and we have the fundamental rights, a potential vehicle for trust. And we have a certain freedom here, a freedom which is being framed. We have the kind of horizontal trust. You are protected by the state, and that is also the trust given that you are protected by the state. So we have a very strong feature here, which is related to fundamental rights and the idea of trust. I did refer to the human declaration, the Declaration on Human Rights. Sorry, I'm not going to further elaborate on that. And we also have the Belgian constitution. It was a liberal constitution, and for those willing to implement the constitution at the beginning of the 19th century in Belgium, it was also, I believe, a way to create some trust. Because in the past we were under the rule of the Dutch, the crown. Well, and then we have the international pact related to civil and political rights. It's another way which dates back to 1966, which is a way to make people free of any type of fear and poverty. Fear is really important here, because if you fear the authorities, if you do not, it's a way not to trust them. Therefore, what we need to do is to get rid of fear with a view to make some space available for trust. So, in my attempt to look for elements which might be a source of trust, I decided to focus on the case law, and that's what I intend to do in the next few minutes. I will broaden the spectrum, of course. I will refer to some domestic decisions. I will just focus on a few extracts of the European Court of Human Rights, and I will also refer to some rulings of the Constitutional Court. And I would like to split my exposé into four different elements. We mentioned it yesterday. Trust is trust in judicial institutions. When you refer to the case law of the European Court of Justice, in 9 cases out of 10, when we refer to trust, it is mainly an issue of trust towards judicial institutions. It's a bit small here. I do apologize for that. But the court insisted upon the fact that judicial institutions were a kind of guarantee for justice. And in that particular field, we need to enjoy the trust of citizens if we want to fulfill the mission of the state. And Mr. Dominat, who gave his name to a very important ruling of the European Court of Justice, because this magistrate shared some opinions and was indeed suspended. So we need to pay attention indeed to trust towards judicial authorities or bodies. And we have other examples in the case law. I'm not going to mention the one of the Constitutional Court. It is of the utmost importance for courts and tribunals to enjoy the trust of the public and the parties who are part of different proceedings, involved in the proceedings. That's another element which is of critical importance regarding the state of law. You need to trust the judge, and it is a way to secure the rule of law, the rule of law. So in the case law, we have those elements which are highlighted because we have judges fully aware of their role, and I've decided to pinpoint their specific role. And secondly, if we want trust to be in place towards the state in general, towards the executive and legislative powers, you need to secure the trust in the judicial power so that there will be an opportunity of having check and controls. Another element here is the link between trust and procedural duties deriving from the European case law. And it is a way for us to arouse some trust in terms of investigation. Just to mention a few elements. Investigations need to be effective and should promote, and this should promote, therefore, a certain trust. In the Honorietis case, there was an industrial accident, and we had to carry out an investigation with a view to determine who had to be blamed for that accident. And this was also a way to restore trust, and there are plenty of other examples I could potentially mention. The Belgian people in the audience do recognize the picture of Mr. Bougé-Mangango. That's a third illustration of the link between trust, case law, and fundamental rights. And it is something related to electoral examples submitted to the court in a ruling of 2020. We have here the more blatant idea of trust. Having regard to the fact that Article 3 of Protocol number 1 is intended to consolidate the public's trust in the Parliament, so we have this right to trust. bearing in mind the conflict, the dispute, an electoral dispute. So from the European Convention on Human Rights, it was considered that we had to identify institutions which would not jeopardize or pollute the trust. And it was confirmed for other electoral disputes with wording such as, well, if you change the electoral legislation just before the election, you might undermine the trust of the citizens. And here you can see this dog with two tails. If you do not have a clear-cut legal base when you want to limit the freedom of expression of a political party, well, by doing that, you undermine the trust. And then regarding the case law, we need to determine whether there is or not a possibility for us as individuals to contribute to the trust in the institutions. And that's we have a ruling of last week, a very recent one, therefore, a doctor who was against vaccines, before during the COVID period, and because of that, it was considered that he could be sanctioned because of his statement. He did undermine the trust of citizens in the institutions, medical institutions, or more general institutions. So in that particular case, it is an example of a situation which might be a limitation of fundamental rights. And we have other examples in plenty of other cases. I will not further elaborate on them, except maybe this case in Portugal. Someone did publish caricatures or cartoons of elected representatives in Portugal, and the court considered that this might disturb the trust people could have in the institution. Of course, it does not explain as a whole the outcome and the final situation, but it had an impact on the final outcome. So this might jeopardize trust. But of course, we need to determine whether fundamental rights might be a vehicle of mistrust. And during this second part, I would like to insist upon the fact that fundamental rights are channels through which we can express mistrust. Martin Laughlin yesterday concluded the panel by indicating that mistrust was needed with a view to produce freedom and liberty. And I would say it is also the other way around. We need to bear in mind this opportunity. But I will leave it aside because fundamental rights do not lead to mistrust, but they are a kind of channel leading to mistrust. And in some cases we might produce some mistrust, and I would like to refer to different questions. Maybe fundamental rights might create some uncertainty, some disappointment, and this might lead to a certain type of mistrust. People are a bit at a loss sometimes because of fundamental rights, because fundamental rights have been developed quite a lot over these last years, and people do believe that these rights are slightly heterogeneous and the basis of a kind of subjective law, and people are a little bit at a loss, If you refer to Article 8, for example, which is related to the right to individual autonomy, but it is at the same time related to the fact that we might be altogether protected at the level of our environment. So the dichotomy between the two might be a bit difficult to bear with for some citizens. The second element has to do with uncertainty. Fundamental rights might create some uncertainty because the scope might might be a little bit blurred, and therefore judges would have to make a clear-cut interpretation of this, and they would have all the power, to make the kind of interpretation they want. It is true that fundamental rights are blurred in some cases, but as mentioned by Justine Lacroix and 𝐁𝐸𝑒𝑁 FRÉDÉRIC, human rights are inevitably open to discrepancies in terms of interpretation, and we need to live with it, if I may say so. You might also be convinced of the fact that it is needed, but it's quite different to explain it to the population at large, to the people at large, because uncertainty is something deriving directly from those fundamental rights. Another question might be related to a lack of efficiency induced by those fundamental rights. That's a kind of shame and blame exercise which does occur on a regular basis. And that's true. That's the kind of approach we might have for a government. It might be complicated to refer to the negative duties which have to do with the history, which belong to the past, and the positive duties. You're obliged to do a few things with a view to serve your citizens. You have a narrow margin of maneuver when you are faced with a pandemic or whatever. You need to protect positive duties, but at the same time you need to protect the privacy of citizens, etc. And you might wonder, what kind of leeway do I have? What kind of margin of maneuver do I have? And this kind of blame we have against fundamental rights is quite useful to populist groups and government, who will use this idea as a kind of springboard. They will insist upon the fact we need to get rid of those frameworks and those frames because they're a little bit disturbing. And that's the kind of approach we have in Western Europe, with a view to get rid of this idea of the rule of law. So it's a bit bothering, because 1 year ago we had a Belgian constitutionalist who did refer to the fact that the legality had been violated because the Council of State, the State Council, insisted upon the fact that migrant people had to be treated in a fair way. And it was also mentioned at the same time, if there is no possibility to do things in a better way to enhance the situation, that's not so serious. So we still have a huge leeway available there, but we just need to spot it and see it. And gradually I'm getting to the end of my exposé. This notion of being disappointed, or yes, being disappointment, and I would like to refer to the work of Kate Layton from the Netherlands, who decided to broaden the insight and insisted upon the fact that fundamental rights were not understood anymore by the Dutch people, because most of the time people do consider that those rights are absolute rights. And the freedom of expression is for me an opportunity to say whatever I want. And I want to feel safe, because I don't want things to be known about me. If you have this type of point of view, you might be disappointed, because the reality is quite different, because the government is in a position to limit your fundamental rights, and therefore you might be disappointed, and this might in turn lead to some mistrust. Another example, in the 90s, the idea or the expectation, the Erwartung element I did refer to at the beginning of my exposé, is probably huge. We are disappointed if we have a lot of expectations. If at Christmas, at Christmas, for the Christmas Eve, we hope we will have a beautiful party, something extraordinary, and if it's not the case, we're logically disappointed. And it might be exactly the same with fundamental rights. We might be disappointed because we have too many expectations, and this might explain I believe, part of the disappointment felt by the citizens. And citizens might also be disappointed for all the reasons I've just mentioned before, because fundamental rights might offer too much, while for other people they will consider that it's not enough. They don't get enough from the fundamental rights. And we have this disappointment. We don't get enough from it, while other activists will consider, well, that's too much. When you're presumed to be innocent, supposed to be innocent, for some people it's not good. For the victims who are not taken on board, because we assume that someone who is supposed to have committed a crime is innocent, and we should, for example, condemn journalists who do not take on board the fact that right from the start we need to consider people are innocent. So that's something which is being done with a view to get more security, to have more risk avoidance. And we know that in terms of fundamental rights, we have an obligation, a duty to act if there is a genuine risk and an immediate risk. It is not a duty to try to monitor all potential risky situations with a view to avoid potential damages. So we always need to take that in place. Marie Jadot was there yesterday. I don't think she's here this morning, but she did refer to civil disobedience, and for some people it was admissible, not to condemn people who committed infringement. For example, to get rid of a poster or advertising related to polluting cars or whatever. You cannot do that. Not condemning those people was considered to be a scandal by some people. Well, other activists did consider, this kind of civil disobedience should be given more weight, because it is an opportunity for citizens to express themselves about bad actions implemented or likely to be implemented by the state. My very first conclusion would be the following. When we take into consideration those elements, I always see a kind of counterpart. I think that in the 19th century we did not have enough protections, and it might explain why people are at a loss, because we have plenty of provisions which do exist today, but we have this genuine protection of the most vulnerable. That's the first element regarding the fact that we're at a loss, but there are protection which are multiple and effective. Uncertainty, but we have evolution and adjustments which are likely to be made. So we always have a kind of counterpart here. And the same in terms of inefficiency. We have anyway the rule of law, which is quite substantial. Without the interaction at the level of the government, the rule of law would not be possible anymore. So in this nice premises where we are today, I do consider that we always have those counterparts elements, and people might most of the time see the negative element, but in terms of disappointment, I think it's quite difficult to identify a positive answer. But I don't want to be too pessimistic, but on the contrary, I would like to be quite positive and have a double avenue to explore as a conclusion. First of all, we need to regulate supply and demand. I'm not an economist, but that's a kind of reference for me, a kind of milestone. Well, what does it mean? Well, it means that we need to think of potential legal evolutions with a view to clarify supply, i.e. demand, i.e. what we are expecting from the government, our expectations. And in the second bullet point, we need to think of evolutions which might be related to education, to culture, with a view to clarify the supply side, if I may say so. So what about demand? Well, I think that legal evolutions might come into the picture, and it could be, for example, the possibility to modernize the list and the catalogues of fundamental rights. The Belgian Constitution, Title Number 2, is a kind of window case. We could reshuffle, for example, review Title Number 2. We might be quite ambitious. Why not? But that's not the most important point for me. The most important thing for me, at this very stage, at least, if we bear in mind the different elements I've pinpointed, would be to refer to the limitations of fundamental rights instead of creating new fundamental rights. Of course, don't misunderstand me. I'm not in favor of limitations of those rights, but to think potentially of limitations, bearing in mind the current changes in our society. What kind of restrictions or limitations are we ready to accept? And maybe we should articulate all that a bit more seriously, I would say, between the Constitution and the fundamental rights. We should rethink maybe the key objectives mentioned in fundamental rights, and to re-articulate the whole thing. Maybe we would reduce or slightly reduce fundamental rights with a view to secure and protect our society, our community, and our planet against the global and climate warming. So that's the kind of potential limitations we need to have in mind. And the very last point I would like to raise is to clarify, if I may say so, the supply side. What do we already have at our disposal? And we should maybe explain it better to those who are at a loss. We should explain it better to those who are disappointed. And with a view to do that, we should try with education and culture, as I said. Democracy, for example, and fundamental rights should be at the right place, or put at the right place within the society, within our schools. When I did arrive to Brussels, I've seen a campaign in favor of the defense of human rights. And it is true that such an institution should have bigger resources available with a view to explain what fundamental rights mean and what is enshrined within those fundamental rights. Parlons Démocratie is an organization which is active in the schools with a view to explain what is democracy. And I'm ready here to make a call. Why not creating something similar? If you're interested, maybe we should visit secondary schools altogether and tell them what human rights are about, what we mean by human rights. And finally, I would like to insist upon the fact that no system at all on earth is perfect, and whatever we might do, any political system will be a source of disappointment at one point or another within the population. Thank you.